what's really happening here? We have pressures from lawyers, I think, who want to expand their practice, who believe that they can practice law across a border.
Some of those COVID changes, like everybody, all of a sudden everybody was doing it. Everybody's work from home, everyone's remote, everyone's hybrid. And so that kind of blurs it a little bit more.
Let's just kind of get down to the nitty-gritty of where can you practice and how do you practice. On a temporary basis, pro hoc vice is the standard. Unfortunately, what requirements there are for pro hoc vice are not standard.
Welcome, and thank you all for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speakers, Charity Anastasio and Micah Buchdahl. Charity Anastasio is a practice and ethics counsel for the American Immigration Lawyers Association. Charity practiced law for 5 years, followed by 10 years in her current role. She is an ethics nerd and practice management ambassador who advises lawyers through consultations, publications, workshops, and presentations. She is in the leadership of the ABA Law Practice Division and was named an ABA 2020 Women of Legal Tech honoree. Micah U. Buchdahl is a Pennsylvania licensed attorney assisting law firms with business development initiatives. Based in Morristown, New Jersey, he is president of HTM Lawyers Incorporated, a law marketing consultancy. Micah is known for his ethics counsel as it pertains to law marketing, advertising, and compliance. He is a member of the Association of Professional Responsibility Lawyers and a past chair of the ABA's Law Practice Division. The webinar that you're about to watch will be approximately 1 hour, and once it is complete, Charity and Micah will be taking questions from the audience. If you have any questions that come up that you'd like to ask them while the presentation is going, please feel free to submit them through the Q&A button in the control panel at the bottom of your screen, and we will answer your questions at the end of the webinar. Now, without further ado, here are Charity and Micah to discuss Your Bar License is Trapped in the 20th Century, or Is It? Multi-Jurisdictional Rules and Proposed Changes.
Thank you, Nina. What a great introduction. Quite a pro. So she already introduced us. Anything you want to add to that, Micah?
No, I'm just, I always enjoy doing programs with you, Charity, because we disagree on a lot of things. And so I always compare them to an episode of Pardon the Interruption on ESPN. But this is a great topic, and it's something that really impacts pretty much every lawyer, regardless of practice, regardless of geography around the country.
I also like presenting with you, not just because we spar occasionally, but because I think it is a really interesting topic that we get to talk about here. And it's just always really interesting to hear your perspective, even though it's not always mine. So high level, what we're going to cover today is getting a deeper understanding of the rules around multi-jurisdictional practice and the unauthorized practice of law, especially Rule of Professional Conduct 5.5 and 8.5. 5.5 is your multi-jurisdictional practice rule, and 8.5 is choice of laws or jurisdiction, depending on what state you're in. Grasping sort of the patchwork of lawyer marketing rules that also interact with that. And then, getting the scoop on the proposed changes to 5.5, at least as much as we know, right?
Sure. I mean, I think, the interesting thing about 5.5 is that, it's the reason I care about it is that I'm working with law firms on business development efforts, and more, the MJP, came into play in terms of issues of unauthorized practice of law and multi-state jurisdiction. And so the more it came into play, the more I had to sort of study it and learn about it and sort of follow its route through the various organizations we'll talk about.
Right. Like it's used as a weapon by law firms. So what's really happening here? We have pressures from lawyers, I think, who want to expand their practice, who believe that they can practice law across a border similar to the way that they drive across the border and still remember how to drive their car. They drive from New Jersey to Philadelphia. They do not then forget everything that they're doing. And then the rules, which really contradict that. And the rules come from the rules of professional conduct in each state, but also there's the I think one of the pressures is that we don't have what the actual definition of the practice of law is in those ethics rules. It's usually in case law, and it's different from state to state. And then that's not even taking into account the federal system, which is defined it in other things. There's the immigration law defines your practice of law in the CFRs, in the regs. And in some ways, I don't think that we actually, that might be a moving target, right? What the practice of law is has got a lot of pressure on it. And that also comes from this access to justice puzzle that we always seem to say, and this is going to solve the access to justice puzzle. And then it doesn't. And the next move, the limited license legal technician, for example, this is going to solve the access to justice problem. And then it doesn't. Or this other option might, and then it doesn't. And then just obviously there's modernization. And what our clients expect from us is that we can practice anywhere, anytime. What our tools offer us is that we can practice anywhere, anytime. And yet what the rules say does not necessarily support that.
Well, I think too, one of the interesting things about the definition of practice is that, for a long time, a lot of, I used to think of jurisdictional issues as being, am I going to appear in court there? Right. Like that to me was, is this going to be something where I actually have to go to that state and make an appearance? Like that to me was practice of law, right? Like not, do I happen to be doing something involving the legal practice in a hotel room in the city, in your state, right? So I think really the sort of the expansion of what practice, what the practice definition, and a lot of it in the end is really, I think it's driven by economics and it's driven by turf, right? Which they go hand in hand.
Right. And really to me, the practice of law is less and less about courts and more about settlement, contracts, administrative agencies and government, all of these other things that are transactional in nature, and yet still usually has an element of practice. And discipline counsel may or may not think that is, the unauthorized practice of law, because the classic rule is where you're sitting. But we'll get to that. So recapping the pressures, really modern world says it's possible, but the rules might not say it's acceptable. Micah, what's the history on 5.5? Rule of Professional Conduct 5.5.
So, looking at this slide, I always laugh about the 2020 Commission because I think it started in the 90s and we're in 2024 and a lot of places haven't implemented it yet. So it kind of reminds you of the speed of light in the bar world in terms of looking at rules. But, most recently, the Association of Professional Responsibility Lawyers, which I'm a part of, had proposed changes to 5.5 in line with, charities thinking, right? In April of 2022, that involved, reaching out to state bars. It involved, reaching out to the ABA and to folks there, the Center of Professional Responsibility in the ABA. And so since, April of 2022, there have been all kinds of committees and commissions and studies and questions and answers. But the reality is that, as far as I'm concerned, outside of a couple of states that have tweaked 5.5 in recent years, I haven't seen it moving very quickly. I don't think there are a lot of changes. And ABA Journal reporter just asked you and I, yesterday, whether there had been any changes since February. And we kind of laughed, because of course there aren't any significant changes since that time. So it's kind of wading its way through. And I think what we'll talk about, in regard to different attitudes and approaches by different states is going to really impact what ends up happening. Because again, I don't believe that there'll ever be true uniformity across the board nationally. But there can be tweaks and there can be pressures. Again, sort of tied to the almighty dollar, that might make some of these things move a little quicker.
The money and sort of the many little fiefdoms that you have from state to state, and that 2020 commission. To my view, they sort of missed an opportunity there where they really could have made a significant change that would have made a lot of sense, and they didn't. And this is where we beg to differ, right? Is that you say, well, nothing has really changed, and I look at the rules on a daily basis with the immigration lawyers, and figuring out which rule applies, and what that 5.5, where that actual authorization is for a federal practitioner to practice anywhere, is a little different in each state. And I think that because they didn't come up with a rule that really accounted for reality in the way that it is, I think a lot of states are changing this rule, but they all change it to their own little specifications. And so it gets really complicated to try and understand the full scope. I think more have changed than you think, though. I think it's more than a few.
Well, I think, again, like it's they might have made changes, but there's not uniformity. And I think if you think about the 2020 Commission and you think about when they started talking and how different the world is today from when they started their commission, pre-COVID, a lot of changes, right? In terms of the way competition is ramped up, technology, etc. Like all those things are a lot different from when that commission got started. And the other area, that I always remind people of when we talk about model rules is that they're model rules, right? They're not actually real rules anywhere. Like states adopt model rules, they adopt parts of model rules, they make changes, they have differences in their ethics opinions and their comments. But in the end, the state decides, what they're going to do.
Yep. And every state has its own texture and character, not surprisingly. And some of them come down differently on this issue, which we're going to get into next. So this is by no means the only case law or information about these, but these are the ones that have really stuck out to me in my research and over time looking at this issue. And Micah, we've pulled these together, and it's kind of a combination of case law, of ethics rules and decisions, and opinions. So the first case that really started the bandwagon, I think, here is a Minnesota case where an attorney from another state, out of the kindness of his heart, helping family members with a debt, decided that he would write a couple letters to try and help them resolve this. And he got a bar complaint in Minnesota, which is where the company that he was sending it to was. And they said that he was committing the unauthorized practice of law, and the court agreed with them. And so he got dinged with a suspension for a certain amount of time in that state. And of course, there's reciprocity. So he probably had problems in his own state. And I always feel terrible for that poor gentleman, because if you think about it, he was only trying to write a couple letters and help somebody. The next sort of big landmark is an Ohio case where an attorney moved from another state to Ohio to take a job, but was still working on the cases in her previous state. She set up an office, applied for bar membership through Reciprocity, I presume, was working on her cases from the previous state only for a little while. And then she got the response that, no, you won't get bar license here. And by the way, you're committing the unauthorized practice of law by working here. And so we're going to bring discipline against you. She quickly brought that to the court. The court agreed with them. They appealed it to the appeals court. The appeals court agreed with them. And then finally, the Supreme Court said, wait. Practicing law isn't just sitting in some location. It is where that actual action, the happenings of things, the impact is. She's only doing work in this other state, even though she's sitting in our state. So we shouldn't ding this person for this. So that was not as easy as you think it would be, right? That, to me, that is surprising that it got through all of those courts until it had to get to the Supreme Court.
I think one thing we find is, there's friendly states and not friendly states. I used to call them I'd sometimes call them sticky states. And so you kind of, across the board, you can kind of see in various jurisdictions, you kind of know where there's going to be problems. And again, it usually ends up being, it goes back to being an issue of competitiveness or people, competing and having various turf wars. So, those are a couple of the, more problematic places.
Absolutely. And I always think that a little state next to big states with lots of lawyers is one that has a tendency to be defensive. And I do think that they change a little bit over time. I'm barred in Washington State. I moved to Maryland to take over the management of the Law Office Management Assistance Program at the Maryland State Bar, and was absolutely flummoxed by this ethics opinion that I read when I first got there that said, if you are working in your kitchen on cases for DC from Maryland and you are not barred in Maryland, we will get you. Like, that's essentially what it said. I was horrified. And I called discipline counsel and said, is this true? Is this your framework? And they said, no, we wouldn't do that. We wouldn't really do that anymore. That was the way it was before, but that's not what we would do now. That still didn't make me feel great. Right. And they have been a jurisdiction that is a little bit more strict because they're right next to DC. I just that little, state next to a big state. You want to be careful. You actually want to be careful about these rules. Is the
we always talk about like New York and basically Connecticut on one side and New Jersey on the other. And so again, that concern about all these New York lawyers coming into your space, right? Whether it's in New Jersey or Connecticut. And so, basically a lot of it is sort of a knee-jerk reaction to that concern.
Yeah. It's generally not client driven, which is one of the points that April made, is that shouldn't clients be able to choose their own lawyer? So back to some of the, main marker points here. We have on here Arizona's change of the non-lawyer ownership of a law firm. That's really 5.4. And that seems unrelated, but you'll kind of notice that these rules are interactive and that comes up also, I think, is an element when law firms or when states are looking at this particular rule and whether or not they're going to accept things. And not all states have been on board, obviously, because Arizona and Washington, D.C. are the only ones that have that non-lawyer ownership permission. Still, years later, I think maybe it's a tougher row to hoe, and there's a few ethics opinions that even go against that. The Utah sandbox is that Utah bar actually went a different route where they created a regulatory sandbox, is what they call it. So companies that have non-lawyer ownership do want to offer legal services, whether they have lawyers in there or not, register in the sandbox. They have to report lots of information. It's kind of a scientific project almost, what's going to happen with it. But it definitely interacts with this. And those two states and those moves, I think, were really, for those of us who want the change, optimistic moments where we thought, here we go. If the ball is rolling, it's going to happen. And then inertia kicked in, much like Micah has always said to me, nothing's ever going to change. And we got an opinion out of New York, an ethics opinion that said, if you're practicing here and you have non-lawyers in your firm, that is still an ethics violation, is the essential thrust of that opinion 1, 2, 3, 4. And then the Missouri opinions that came out in 2024, which you found, what do those say, Micah?
So, so in I don't know why it came up in such rapid succession, but in January, Missouri issued 4 successive opinions, all of them touching unauthorized practice of law and MJP. One dealing with in-house counsel, another dealing with a virtual law practice. Basically all of them, if you go and you read them, they all basically say that, that if you are breathing in their state, and you even think about practicing law in any way, shape, or form, that you're violating the ethics rules. And so, it's, again, a lot of these opinions, when I read them, they're nonsensical. I'm in a couple of weeks, I'm going to be in Missouri, right? Like, I'm going to drive my daughter back to college, and I'll be at a residence inn for a night or two. And, is it likely that I will open up a laptop and work on a matter? Well, we're videotaped here, so I'm going to say I'd never do that. But, obviously, right, like you're working. And so, I'm not there practicing Missouri law, not going to court there. I'm not taking any dollars away from any Missouri lawyers. But Missouri is one of those states that has a lot of still, very backwards type rules and regulations, and they still continually issue these ethics opinions or these informal opinions that make no sense whatsoever. So I sometimes wonder, Charity, you look at Arizona, which is what we would call a friendly state, right? And so, I have many law firms I've worked with where they've purposely opened up an Arizona office because it's so flexible, because it's so easy. Why is it that Arizona would see these, what I would consider economic benefits of being a little bit more open? I'm not going to say looser, let's just say open, to other lawyers and other jurisdictions, versus a place like Florida, which we consider to be pretty much the counter opposite when it comes to, stay out. And, they're both, to me, they're both like those places where you kind of semi-retire to and you vacation at, and but they're polar opposites. One
Snowbird vibe.
Yeah, exactly. So they're, so what makes, why is Florida so different from Arizona? Just in terms of their sort of openness, and again, Arizona's a model. I would think that for you, right, Arizona would be kind of a model of what you'd like to see across the board.
Yeah. And actually, you look at their 5.5 and it's so clear and you can understand exactly what you need to do. It's sort of delightful to read. Whenever I get an immigration lawyer from, calling from Arizona and saying, can I practice here? I say, absolutely. If you're exclusively doing a federal practice area and you don't hold yourself out as working there, you can, and it's clear as day. And then you look at some of these other states and it's almost as if they've intentionally kept the obscurity, or they even specifically know that they have to permit federal only practice areas because of the Florida v. Sperry case, ironically happening in Florida, right? Which was a Supreme Court case that was decided in favor of the lawyer who was a patent lawyer. And he said, I'm authorized under this federal statute, which has supremacy, to be able to practice anywhere. Why can I not practice here in Florida, even though I don't have a bar license here? When the CFR say, if I'm licensed in any state, I can practice this area of law. And he won that case. And the states have begrudgingly, I think some of them have said, okay, well, fine, you can, but Missouri, your example of a less than friendly state, even says, well, you can if you're doing only federal, but you're not authorized to set up a continuous office, or then presumably market. So I don't understand why some states are. Maybe it really just comes down to Florida already has over 100,000 bar members, and they have people that are much more interested in protecting their interests. And Arizona has got too many clients and not enough lawyers. and they say, actually, we really need you here. Maybe it comes down to that.
Maybe. So let me add on to this when we're talking about state specific stuff. So Michigan is one of those states that did, modify 5.5 recently. They went and made their changes. It took effect in just this past September. And so they basically said, they kind of loosened up their rule to make it easier for people to practice there. They said basically it's okay to practice there if you don't hold yourself out as having an office, if you don't have an office there. If you're not providing, sort of state-specific legal services there, and you're not offering to provide legal services in the state. So they said it's basically okay to be physically present in the state. Just, don't be practicing Michigan law. But that's the kind of change. That's the kind of alteration that a lot of folks are looking to, at least when you're talking about, it might not help you with the driver's license aspect of crossing borders in practice, but at least the fact that you can be, you can live there, right, and practice law in another place, right? Like you can be a virtual law practice. You can work out of a hotel room. You can do whatever you want, as long as you're not, making it look like you're licensed there.
Right. And that's very similar to the change that Utah did to their rule. And I actually would attribute that change to the pandemic, because I think there were so many lawyers that were leaving certain more populous areas, maybe going and staying with family in other states, and really needed to practice somewhere. And they did it sometimes they authorized it on a temporary basis. We actually have this in another slide. Sorry. But they authorized it on a temporary basis, and some of them have rolled those pandemic exceptions back, but some of them, I think, realized, hey, the sky did not fall. Let's keep this. This doesn't hurt anything, right?
Well, I think I know a lawyer who's been, I'm not going to name the state he's in, but he's been practicing law, out of a condo in St. John for probably 40 years. And so, excuse me. So, it's like, he did that forever and nobody cared. Right. And so it's really just post COVID when all of a sudden everybody started doing it, and then states started looking at it. Otherwise he would have sat there thinking like, what's wrong? Like I would never even thought there was anything wrong with it when I started doing it, 30 years ago. Right. So, so some of those COVID changes, like all of a sudden everybody was doing it. Everybody's work from home, everyone's remote, everyone's hybrid. And so that kind of blurs it a little bit more.
Right. When I started doing the practice management advising work at the Washington State Bar years and years ago, I remember a member talking about how he had he lived on one of the islands in Washington State, which is lovely, and he was international law, in-house counsel. And international, I think, is probably the places where this really in some ways started, because it doesn't make any sense for him to have an office that is beyond his home, because all of his clients are not here and on weird time frames. And so he practiced that way for 30, 40 years and nobody ever noticed, right? But now we are there's many exceptions for in-house counsel. It's one of the biggest ones in all the states I see, as are the federal only. Some of them make it clear and some of them don't. But let's talk about, let's just kind of get down to the nitty-gritty of where can you practice and how do you practice. On a temporary basis, pro hoc vice is the standard. Unfortunately, what requirements there are for pro hoc vice are not standard. All states are different. All states have their system. You cannot presume you will get it, right?
That's the biggest thing. That's the biggest thing on sort of the marketing side of things, is like when I always tell people, you can't presume pro hoc vice. Like you can't just assume like, oh, I'll go get a piece of work out of Kansas and then just get admitted pro hoc. So you can't assume that. And also you have to be careful with how often you go back to the well, right? Like a lot of states will start looking like, okay, this is the 5th time, like you should be licensed here. you can't keep doing this. And so, so there is a big difference between sort of how you approach it and how often.
And you really have to look at their intention behind that rule, right? It is intended to be temporary. It is intended to be for one case. It is intended to be for, oh, this case has expanded its borders where I have to address this issue in another state, but it's still the case that is in my normal jurisdiction. Admission by motion is similar, but it depends on the state and the type of cases and the type of court, whether or not that's an option. We talked about the pandemic extension exceptions being extended in some states, but don't presume it will just because you were authorized 2 years ago. You're going to want to look at the rules again to make sure. And then there's a lot of little minute kind of exceptions. And I mentioned in-house counsel, but I see in some 5.5 rules or even in other rules, they cite other places sometimes where there's exception for military spouses because they move so much and it really makes their bar license just worthless almost because by the time they actually get admitted by, some why am I blanking on the word? Their, reciprocity or comity, whatever the state calls it. When they finally get that, they're getting assigned somewhere else. So there's some exceptions for military spouses in a few states. The UBE, the Uniform Bar Exam, has some elements of exception to it because now that more states have it, you might be able to transfer it here or there. And then there's some states that actually even have pro bono as an exception. Ohio is actually one of those where if you're doing an authorized pro bono work, you can do it in that state as long as you've signed up by a particular rule, you've registered. So those are temporary. Some of the permanent options, federal only. Florida v. Sperry case. If you practice solely in a federal practice area, you usually what the immigration lawyers that I work with at American Immigration Lawyers Association do is on all of their communications, they say where they're barred. I'm barred in Florida practicing immigration law exclusively. And they will put that on their business card, their signature block, their website, every communication, because all it says in the rules is your letterhead. But most of us don't use letterhead that much in the different practice areas. So just put it on everything. Make it very clear. And then you have to avoid actually practicing locally. So if there's a state issue, you need a local counsel for that issue, somebody on staff or somebody outside of your firm that you associate with. In-house counsel, that Missouri, one of those Missouri decisions was actually said that in-house counsel has to be barred in Missouri. That shocked me. That's the first time I've seen that as not an exception.
Yeah, I mean, I always just, even I had an in-house role not long after I passed the bar, and I figured you really just needed to be licensed somewhere to be like a member of the bar someplace, and then it really didn't matter where you were operating. Of course, like again, I wasn't necessarily going. I wasn't going to court. Most in-house are not going into court, right? Like, and they're going to use local counsel in those types of situations, but. Also talking about federal, there are places like California that say, like, if it's a federal practice, you can be from anywhere, right? Like, we don't care, as long as it's federal only, as you said. So it's really, I think the other thing too is, a little bit outside the scope of the bullet points on this slide, is, talking about, you and I have had a lot of conversations about New York, right? And so, up until, New York still has what many consider a very archaic physical office space requirement. That's,
Bona fide office.
Bona fide office in New York. It's one of the very few places that still has that requirement. And so just recently, it looked like that was finally going to be removed. And I know, what big law firm doesn't have a New York presence? They always want to have a New York presence. It can be very expensive. And so the House and the Senate had, basically, working together with the bar, basically were eliminating the need for a bona fide office, a physical presence. And so just that was just recent, like in the last, 9 months or so. And all of a sudden it was rejected by the governor. Like it was quashed after making it through the bar and everybody and every place else. The governor quashed it. And so it's still in place. And, you and I have had conversations. I'm like, well, somebody's got some, powerful lobbies, whether it's commercial real estate brokers, maybe it's local trial lawyers, so it's just interesting that you do have these situations where they finally get to the point where, again, someone trying to establish an office in New York is then basically told or reminded that you need to have a bona fide office. Now, are there lots of law firms that have improper bona fide offices in New York? Absolutely.
So many flying under the radar.
I see them all the time. I end up saying to firms like, "Is that a real office?" What are the what? So it's interesting when you just look at it from sort of that standpoint, which again lends itself back to sort of economic protections.
Right. And practicality lending itself, it makes great sense. We could all be virtual. Why don't we permit this? Realizing that there's other forces at stake here, because I thought of course that would pass, and you corrected me, and thank you for doing that. I will give you that point. You did get that one right.
Well, who knows? I would think that the governor would be the one that said oh, bona fide offices, right? Like nobody would think that, right? Like it's usually people at the bar that are, again, protecting their own turf. It's so, again, they had powerful people in powerful places, eliminating the attempt to make it easier to establish an office in New York. Everyone wants to establish an office in New York, and they're going to make it hard for you to do that.
Yeah. Some jurisdictions have some permitting of mediation and arbitration that's pending. Some of them specifically say that it has to be originating in your own jurisdiction, though, on negotiations or mediation or arbitration. Many permit you to have local counsel. So sure, you can do things with local counsel. And some of the little nuances on that in-house counsel exception that I'm seeing in some of the states now too is that they say you can do this as long as it's an activity that doesn't require pro hoc vice. So basically, probably not court, but you want to make sure you look at the rules and see when it is that they say you need that, and you're giving advice that has originated from somebody that is local counsel. So to make sure that you don't just not have local counsel, that you still have the right people telling you the right things. Already mentioned the pro bono. In some places, that's a permanent exception, and authorized by local jurisdiction. I've also seen like some of them say authorized by Ohio law. And in one, I've seen tribal law. So that's an interesting one. That's probably mostly West Coast. There's many tribes with their own sets of rules, and actually most of them don't require bar admission at all. So I knew somebody that was practicing law when they were in law school in tribal court. So you've got to look at the rule. That's the importance of it. The other piece here that is really, I think, super important is often the first step is saying, well, can I practice there? But then you need to ask, if I practice there, what set of rules is actually going to be applying to me and when? And this, I think, is one of those steps that we sometimes forget. And so I go through this all the time with immigration lawyers. So I want to make sure that you all know this you know how to do this yourself. So this is really the interaction of the multi-jurisdictional practice rule with choice of laws. And the main things that you're going to ask at the facts first are, where are the lawyers barred that are involved in this? Where did the work occur? The sitting in the seat. Is that practicing law? Comes into effect here. Where is the firm? Where is the court? Where are the clients? And where is the dispute is also a good question. And then you sort of take all those together, and then I pull out that rule for whatever jurisdictions are relevant. And really, you have to look at both or multiple jurisdictions sometimes. Most of them say, very close to the model rule, they will say, you're always subject to jurisdiction where you're barred. And you may be subject to the jurisdiction where you're not barred if you offer services, or if you offer services or provide services, legal services in that jurisdiction. And then it says, well, then which one is really going to win out? And that usually comes down to, if a tribunal is involved, it's where the tribunal sits, unless the tribunal says otherwise, which sometimes they do. Like they might be in Washington state, but to say, I believe here Oregon law applies because of X, Y, and Z, which is usually classic choice of laws analysis, which is very close to what that rule is. And then the second part of this rule is if no tribunal is involved, which is, when you think about it, most of what you do with a client. And this ethics opinion by the ABA, formal opinion 504 that I cite down there, they specifically talk about this and say basically everything pre-trial is tribunal not involved, everything pre-trial. Then that means everything else, they say where the action occurred, unless there's a predominant effect elsewhere, and then it's where the predominant effect is. And then they have one little safeguard for you that says, if you reasonably put it where you think the predominant effect is, then you won't be penalized for it, which I would sort of doubt. Because I think you got to do the analysis to get the predominant effect right sometimes, unless it's really, really messy. And so many immigration cases are. Now, there's a few states that are really interesting in that it's almost like they don't want jurisdiction. New York is one of those where it doesn't have any of that second part of it. They just say you're subject to the jurisdiction where you're barred. And if you're barred in two places, that's what they think of as the choice of law. If you're barred in two places, we'll answer the question of which one. But they say nothing about if you're not barred there at all, which I think is a little scary. And I always used to presume that your discipline counsel would want to apply their own rules, which I still think is kind of true. But I have seen instances where discipline counsel will be elated to apply a set of rules that, even if it's not theirs, benefits them for what their goal is. So don't make assumptions on this. Do the analysis, know where it is. I like to tell attorneys to put a choice of laws clause in your fee agreement. It's one of the only ways that you can protect yourself. But as that opinion cites, 5.4 opinion, those choice of laws clauses don't always survive a dispute. And so making it really obvious. Actually, what's interesting about Arizona rule on their 5.5 is they even claim jurisdiction in 5.5, not just 8.5, but they specifically say that you have to do informed consent with clients if you're going to be practicing there without a license. And informed consent is a pretty high bar. It means you've had a conversation with them about the proposed course of conduct. You've given them the risks and the available alternatives to it, which is, and then they sign off on it. So that was a lot of information. Thing that I missed? Anything that I missed?
No, we got to move quicker. We got 15 minutes left.
Yep. So make your license as versatile as possible. Look for states with the UBE. Look for ones that have good terms in their 5.5. I've named a few there. There's other ones. If you want my list, feel free to email me, which my email is on here. I'm always looking at them and adding new ones to the list. Yeah, I have to add Michigan, which you mentioned, Micah. Look for states with reciprocity with the states you're interested in. Those are usually neighbors or ones with similar requirements, but it won't be all of them. Reciprocity is not an easy way. Pick an only federal practice area. I'm a big fan, or in-house counsel. Don't dabble in state law, though, if you're there. And as we mentioned before, identify yourself. And then keep an eye on those rules, because sometimes you have to certify things like specific certifications about malpractice insurance in Oregon or registration requirements in New Jersey. Each state is different, and they change their rules more than you think they do. Okay, this is you, Micah.
So again, like my interest in UPL and MJP really revolves around law firms, business development efforts. And, a lot of times, a lot of the things I work on deal with class actions and mass torts, a lot of PI on the ethics side. And so, so what are you looking at? So when you're marketing yourself and you're concerned with UPL, which is often, a lot of people think like their biggest concern in advertising are the advertising regulations. They'll be like, oh, I forgot to put attorney advertising, or I used the word specialist, or, XYZ. That's not really where it comes into play in real life. Where it comes into play in real life are UPL. Okay, that's, and so, so I always sit there and go, okay, like when I look at an ad campaign, or I look at a law firm's website or anything else, I start with, where are you licensed? Okay, so I make the list of licenses. Where do you have an office? So I look at the offices. When we're advertising, which states are we targeting? Especially today where, 95% of the stuff I look at is digital. And so if I'm looking at a Facebook campaign, I want to see the list of what states we're targeting. Because now we're within we're within their borders, right? In terms of marketing. And if it's a particular, let's say it's a catastrophic event, where does it take place? And so when you start marketing for people, in that place, do you have a tie in terms of licenses? And so, just, associating with local counsel is kind of key, but it's not the only thing. You can go to the next slide. So here's one of my favorite activities when I drive up and down I-95 from my house in South Jersey to Philly, is to look at a zillion lawyer billboards. So many. Probably half of them don't comply with the rules of professional conduct. So luckily, PA is one of those states that I consider, for better or for worse, one of the looser in terms of enforcement. That's my personal opinion. But so you have this, pond hockey, all legal matters, anytime, anywhere. So do you have a licensed attorney in Iowa, and do you follow all the rules of the State Bar of Iowa? Okay, so maybe you do. Do you really handle all legal matters because you're a workers' comp firm? So it's just a matter of, again, like looking at the messaging. We can go to the next slide. And, so, and something I've talked about a lot, and it really relates here to aspects of multi-jurisdictional practice, which is what I call the Morgan and Morgan effect. Something I wrote about. I think it's in the written materials, or it's on the ABA website. And so it's really the impact that Morgan and Morgan has had on lots of law practices, where all of a sudden you're competing against this firm that came out of, to you, it might have come out of nowhere, and has really sort of forced change in the market. And so, a lot of those billboards that I look at come because of, Morgan and Morgan being there. And let me specify, Morgan and Morgan, okay, does have offices, bona fide offices in every state, and licensed attorneys in every state. They're not sitting there with some little, semi-bogus disclaimer that, we only practice where we're licensed and we use local counsel, right? Which I do use all the time, that language. But you can't just use that willy-nilly, right? So in the case of, one of the reasons I like to use this billboard, besides the fact that I spend half my life at Citizens Bank Park, is that you see Saltzman-Zaluzzi at the top there in an advertisement. If you're from these parts, or you're involved in the PI world, they're probably one of the most prominent firms in PI in the country. They never advertised anywhere up until the last couple of years. You never saw them do anything. And now they're on the radio and they're on TV and they're on the scoreboard. They're there on the top, and you see Morgan & Morgan is there on the bottom. And then you see Jeff Rosenbaum's ad, hitting at John Morgan. And again, it's a reminder of why we need these aspects of flexibility, because we're competing against these national firms that have a lot of money and are coming into the space and really branding themselves well. And so, if we don't allow smaller firms and a lot of practitioners a little bit more leeway and flexibility to practice law outside of a very specific box, it's going to be very hard to survive. You can go to the next slide. Again, so on one side I have, Morgan & Morgan, and on the other side, here's Gordon Reese, which again, like they advertise, and they do, that they have offices in 50 states or attorneys licensed in 50 states. Now, do they make sure they comply with the nuances of the model rules for every one of those 50 states? Unless they changed some things recently, I would say no, okay, because I've looked at the stuff and it's like, okay, well, you don't have this from New York and you don't have this from California, or you don't have this from Florida. And so, so it's really the concept of competing with national law firms. And, do you comply beyond having a licensed attorney there in terms of the rules and the regulations? And again, that's where making 5.5 more of a reality is important for the survival of a lot of practitioners. I've had lawyers in certain spaces who have told me that they've gotten, killed, right? Like that they can't compete anymore in certain practices because of the influx of some of these, sort of large branded firms. We can go to the next slide. So, when I talk about MJP and UPL, it's always interesting too, because, when you talk about how you identify yourselves in terms of where you're licensed to practice law, something brand new, something I read this week, there was a matter in Florida, the law firm Kennedy's CMK, which had been, had a grievance filed against them because they had basically listed attorneys saying that they could work on Florida matters, and they were not licensed in the state of Florida. Okay, so it's as simple as that. All right, it's a law firm website. They say they can help handle your matters in Florida, and you don't have and the attorneys that you list aren't licensed there, or you don't have licensed attorneys there. So now in this case, I would assume, or I would guess, educated wise, that that they were a first offender, right, in this kind of thing. And so they basically went and said, oh my God, I didn't know. And they made all the changes and fixed it. And then, basically the grievance was just recently dropped this week. But it is a good example of, when you put stuff up online and you identify yourself as, being able to handle a matter in a particular place, you better have a license, and you better be barred there.
And people are watching. And it's
And
usually other lawyers.
It is usually other lawyers. So, right, it's like 0.1%, is it a consumer who files the grievance? Most of the time it's going to be other lawyers, competitors, right? Like it's going to be competitors. In some cases you have, the non-friendly state bars, which are proactive and being aggressive and looking for violations. And then the area that's really kind of taken off tremendously over the last few years are, often against plaintiffs firms or defense firms that are looking at the solicitation rules and looking for violations and calling out the plaintiff's firm in front of the judge, whether it's to try to get you knocked out or try to get you dinged. It's a huge piece now. It's often I'm looking at the advertising and concerning myself whether, how is a defense firm going to use some of this to their advantage or for their advantage. So you want to pay attention. We in April of 2022, the ABA opinion 501 on solicitation is a good one to look at.
Yep. We do have some information here too about reciprocity. As I mentioned, not cheap, not easy. Usually requires a fair amount of time being there. I wouldn't recommend that as a way to easily practice somewhere. There are some weird multi-jurisdictional practice issues. I see some lawyer account, trust account issues, or client trust account issues, some states call it. Your IOLTA. This can be really tricky because even if you're authorized, it doesn't mean necessarily that the banks know you're authorized. So sometimes you have to actually get permission from the bar. Sometimes the bar says, sure, you can have an office here, but you can't actually have an account here. So I have, some lawyers that are practicing out of the country and they have to have a bona fide office in New York and an IOLTA account in New York, even though it doesn't make any sense. And they come back from, UK just to handle their money sometimes. Death, disability, and disappearance, I will just emphasize for you. All of us know that we need a succession plan. Few of us ever actually have one. If you are a multi-jurisdictional practitioner, you need it more than ever, because that bar where you're actually practicing, if you're not licensed there, has no obligation or interest in helping you if something terrible happens to you. And then every once in a while, I see no jurisdiction apparently applies, and that can be really hard with the 8.5. We have a few questions. Let's see. I thought this one sounded really interesting. I am licensed in New York, but living in a different state. I do not say anywhere that I am practicing the law of the state in which I live. I maintain New York office. I do not intend to avail myself of the courts of the state in which I live, nor do I hold myself out as an attorney of this state. Is it going to be possible one day for me to live in my state without fear that I will be tagged as practicing without a license here? What do you think?
Is it possible? Yes. Is it probable? No. Right. I always say, Charity gave that example of, doing something in her kitchen, right? Like, I don't think any bar association is going to show up at your door peeping through her kitchen window to see if she's got a laptop open. And so it really is a matter of, of how you present yourself and whether you put it out there in a way that makes it look, like, let's say, for example, let's say you live in, I don't know, let's make up a place. Let's say you live in Rhode Island, right? And so maybe now you're in Rhode Island and you start going to your kids' soccer games. And you start talking to parents on the sideline, they start talking to you about what you do, and you say, I'm a lawyer and I do X, Y, and Z. And they go, well, that's interesting because I have this matter, right? Like, you wouldn't think about, like, oh my God, I'm engaged now in the unauthorized practice of law. I'm only licensed in New York. But that's probably kind of the type of scenario that could come up that could be problematic. But again, if you, I don't want to say lay low, but it's really a matter of whether, are you going to create a situation where you take a penny out of a lawyer's pocket in that state? And if the answer is no, I would think that in the overall scheme of things, you'd be okay. But also,
and I do think the level of contentiousness of the practice area and who might be, doing it matters.
Oh, totally.
Yeah. Someone asked about what about if they took the bar before the UBE? You can always take the UBE again if you want to. But I think probably if you've had a license for a while, you might be looking at reciprocity as a possibility. Just realize sometimes it takes a long time. You need sometimes 5 to 7 years of practice in the area. You have to show it can't be like some states don't allow it to be part-time. Certain states have reciprocity with other ones, but not many others. It's a talk about patchwork. It's complicated. Have either of you seen commentary or comments to the rule on unauthorized practice that says something about helping someone represent themselves being excluded? Oh, that's a good question. I would suggest looking at the limited scope representation rules. And those are scattered in different parts of the ethics rules. Sometimes it's 1.14 a little bit, but that one is no.
You know what, you might know, you'd know better than me, but in that kind of a situation, are you making an appearance? Do you put your bar license number down
It
when you're
depends. It depends on the state. And I'm thinking of the federal ones, which the limited scope representation requires them to do a different form that says, I'm not the attorney of record, this person's pro se, essentially, but you still are signing on as I've helped them prepare and ghostwrite this. And I think that's still, I think it was very clear, at least to Ethics Council federally, that that was still the practice of law. And that actually lawyers could not be just preparers. They brought a suit against Northwest Justice Project for that. And that was their position, that lawyers could not be simply preparers, even though somebody that didn't have a law degree could. It puts us in a real bind.
Yeah, let me add, as I read these questions, these are our personal opinions. They're not legal advice, and they don't represent anything official for charity or myself, because again, a lot of them are, one thing I often tell people about the ethics practice, and it's probably true in a lot of places, but it's very subjective, right? Like our opinions are very subjective, and so the way I answer a question might be very different from the way another ethics lawyer answers the exact same question. And so and to me, like, I operate in the, I always tell people I operate in the real world, right? Like, I operate in the real world. I don't sit there and think, what if? And so, so that's what most of us need to do is, function in ways that, I'm often trying to minimize any problems that I try to minimize the possibility of a grievance, the possibility of giving the defense counsel ammunition, I'm looking at things in that way, in that capacity. So, so a lot of the questions that I see up here, again, it comes down to, ask yourself this, if the state bar or the court or opposing counsel, if they knew what I was doing, would I be in trouble, right? Like, that's the way I look at it, at a couple of these questions, right? Like, and so you got to be smart about it, and you got to ask yourself that question. Like, and you do have to look at the specific state. Like, every state's very different, and as Charity said, things change by the day. Something that I tell you today might not be true tomorrow. I know that goes for everything, but you really have to pay attention. A lot of states, it kind of there's an ebb and flow to attorneys that are on certain, grievance committees or disciplinary boards, the Supreme Court judges of various states, the people that are presidents of the state boards, they come in and they have their pet projects or their pet peeves. And all of a sudden, what was good yesterday isn't good today, and might change tomorrow as well. So you really need to look at the specifics. Like, I'm looking at some of these questions that are very specific to states. I'm in California, I'm in Minnesota. Like, I'd always say, if you were my client, like, I'm like, okay, well, I got to go look at Minnesota, right? I got to go look at Minnesota. I got to go look at California. I've got to go look at, this question. One of the deals with BLP in Minnesota. I would have to go see, what the BLP attitude is in that state and what ethics opinions there are. So you really need to be specific by the state.
And one person asked about whether or not, if they're on vacation and the client asks the question by email, can they technically even answer the question? And that's a great example of, it depends on the state whether or not that would be considered the unauthorized practice of law. The state that they're from, but more importantly, probably the state that they are in. Now, if you're out of the country, I bet you're fine. But if you're in the U.S., don't do it in Missouri.
And there's a question. I know we're out of time, but there's a question here dealing with Delaware. And again, Delaware is very provincial, very, they're very strict. That, the way the chancery operates, the way the courts operate there, the way the bar operates there. Like, if you, don't go playing in Delaware if you don't have a Delaware license, or, that's one of those states you just don't want to play around in. And again, that lends itself back again to the concept of competition. One thing that I wanted to get to, and I want to just throw it out real fast. Like one of the things going on in New Jersey right now is basically a prohibition on New Jersey trial lawyers paying a referral fee to out-of-state lawyers. That's like a big thing right now going on in the state. And again, it lends itself to turf and economics, and it's kind of crazy, but it's really kind of about who gets that 1/3 of the money, right, or who gets that percentage of the pot, and whether or not you can keep it in New Jersey and not have to send it off to the lawyer who sent it to you from Pennsylvania. So all these things that come into play. Again, it's a rapidly changing area, and and again, we'll see. Maybe more people will be like Arizona, right? And in terms of the approach they take.
Let's hope. Let's hope, because I want you all to be able to drive. I believe that all of you can do legal research skillfully. Any state that you are in, you won't know those little funny nuances. That's what they say is the big problem, but I don't believe it. I think we're moving in the right direction. I believe we'll see change.
So if we didn't answer, if we didn't answer your question, you see our email address is up there. Feel free to give us a shout. I might not want to put my answer in writing now that I think about it, but but certainly feel free to ask us. Again, it's a great area, and it's an area that impacts everyone, and really it's a matter of kind of trying to play within the rules, right? That's what we all try to do when it comes to law practice.
And a great solution for this too, if you're really worried, is you can get an ethics opinion from an ethics lawyer, and I have good references for those. So, feel free to contact me and I can set you up with someone.
All right. Nina?
Awesome. Thank you both so much for your presentation, all of those additional insights that you provided in answering our audience's question. For all the lawyers who are here today, we have a great tool for you to help you get leads you're looking for, whether that's in a multi-jurisdictional practice or just in your regular practice, single state, Justia premium placements. So these placements that you can get through the Justia Lawyer Directory allow you to be seen above the organic results, whether that's a fixed number 1 placement with our Justia Platinum placements, or ranking highly above the other organic profiles with a Justia Gold Premium placement. Those are available. So if you'd like to contact us about that, you can always reach us at marketing.justia.com. Thank you all so much for joining, and have a wonderful rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.